for our webinar. Good morning, everybody. Thanks for joining us today for our webinar on data share agreement basics, best practices, and challenges. So we have done a presentation like this before, but this presentation today has some updated content that we wanted to share with all of you. For those of you that don't know us, my name is Katie Ruckel, and I'm the state's Chief Privacy Officer, and I'm joined today by Matt King, who's the Privacy and Data Manager or Data Protection Manager in the Office of Privacy and Data Protection at WATEC. So I'm going to do a quick disclaimer that this presentation is for general informational purposes only and is not legal advice. The information provided reflects the Office of Privacy and Data Protection's current understanding. Best practices change over time and according to context, so you should consult your assigned AAG or Assistant Attorney General on specific legal questions. So that's the disclaimer for today, and now we're going to jump into our agenda. So Matt's going to start us off with a little bit of a data sharing agreement 101 and where we are today in terms of the requirements for DSAs in the state. I'm going to talk about the consideration for some of the data breach provisions that you may include in your DSAs. We're going to cover AI implications and some of the issues we're seeing in terms of incorporating different terms regarding artificial intelligence into our contracts. Matt will also talk about international data sharing considerations, and then I'm going to finish up with third-party data requests. So let's go ahead and get started. I'm going to turn it over to Matt.
Thank you, Katie, and good morning, everybody. We're going to start by just sort of setting the baseline understanding around data sharing agreements before we get into some more specifics and kind of hot topics around DSAs. So DSAs are a long-standing best practice that help us with some key things like understanding where our data is, as well as making sure we have appropriate security controls in place and privacy considerations so that the information is being used for appropriate purposes consistent with why we collected it in the first place. But aside from being a best practice, we also, as public agencies, have legal requirements to put DSAs in place. So in 2021, there was a new law passed to put into law some of these requirements, and it resulted in two separate sections of new law. The first one is part of 39.26 RCW, which is about the procurement of goods and services. So this one is specifically about sharing Category 3 or higher data with a contractor and establishing that you need to have a DSA in place and that it must comply with specific policies enacted by the Office of Cybersecurity, which is really our WATEC statutory authority to enact enterprise policies. The definition of agency in this one applies specifically to state agencies, which is slightly different than the other section that was part of that law, which is part of the Interlocal Cooperation Act. So this one applies not only to state agencies, but also to local agencies. And this one specifically applies to sharing information between public agencies. Again, it must be consistent with established WATEC policies. So these two sections cover probably a vast majority of the amount of data sharing that agencies do, but because of the specific scope, there is like a little bit of wiggle room where you could find some daylight in between there. But we also have a statewide policy, which is our data sharing policy, or Security 08, which has a broader requirement that applies to really any data sharing, which is that agencies need to enter into written data sharing agreements when sharing Category 3 or 4 data outside the agency. When we think about what it takes to implement a DSA, we can grossly or drastically simplify it to these three steps of identifying when you need one, implementing them, and then monitoring them over time. all three of these steps do have some unique challenges. So the first thing is going to be identifying when you need an agreement. So one tricky thing here is what the definition of data sharing is, and we often have misconceptions around this, but we really think about it broadly in terms of any time you're making data available to a third party. So that could be any type of data processing by a third party. So the most common thing that we think about, or the first thing that often jumps into your head, is around data transmission. So like literally setting up a data extract to send to somebody, and it certainly encompasses that, but it also includes other types of processing. So things like data hosting. So sometimes we get questions of like, well, this vendor is hosting our information, but it's encrypted and they can't access it. But they still have control of the data. They're still processing the information, and we'd still consider that to be a form of data sharing. And we get similar questions around system access, where somebody isn't actually receiving an extract or a file, but they are able to get access, normally remote access to data, and that is also a type of data sharing. The other piece here is that there are many types of third parties, right? I just talked about contractors or vendors as one of those legal requirements. And we also talked about other public agencies. Other common categories include researchers or community partners who are serving similar communities of people, but maybe aren't our contractors. And so again, sometimes we get questions here of, oh, they're just a contractor and they're working on our behalf. Do we really need a DSA? The answer there is yes. And similarly, we get questions around, oh, we're all the state. Do we really need DSAs between agencies? And again, the answer there is yes, not only in policy, but also in law. The other piece of identifying when you need a DSA is the data classification piece, which is that this requirement applies specifically to category 3 or 4 information. So I won't belabor this too much here. We have entire other webinars on this topic, but the basic idea is this applies anytime you're talking about confidential information. And confidential information is information that has a specific exemption to public disclosure under the Public Records Act. The next piece is about, okay, you've identified that you're sharing data. What do you need to do to actually implement a DSA? And the big thing here is understanding that a data sharing agreement is not a defined term. It's really something where we emphasize substance over form. So especially after that law was passed in 2021, there was a lot of consternation around, do we need a explicit standalone agreement that is literally a quote unquote data sharing agreement? And the answer is no. What you need are terms that describe the conditions of data sharing. So that could be in a standalone data sharing agreement. It could be an appendix to another contract. And then, depending on the type of relationship you have, we often see the terms incorporated into other types of agreements. So it could be in the terms of service or an end user license agreement, as long as those agreements include appropriate data sharing terms, which I'll talk about in just a second. So what this means is that the level of specificity is also going to vary quite a bit from contract to contract. It's not always going to be the same agreement that you're implementing, but in practice, what we find is that the higher risk there is associated with the data sharing, and the more sensitive the information is, then the more likely it is that you're going to need very specific terms to govern that. And then the other kind of reality here is that if you have arrangements where the only reason you have a relationship with the data recipient is because you're sharing data, that's probably going to have much more specific terms associated with it, rather than like if the data sharing is incidental to a vendor relationship where they just need it to do work on behalf of your agency. So the context really matters a lot and influences what those terms look like. In that data sharing policy I mentioned, we do have elements that are commonly included in these data sharing agreements. And these are terms that where we would expect the topics to be addressed, but again, the level of specificity is going to vary and is a bit of a risk exercise and is going to depend on the type of data sharing, the type of relationship, and again, the sensitivity of that information. But these are the general types of things to consider. And when you're looking at a data sharing agreement, you want to go through and map against this and see what gaps may exist. Once you've identified and implemented the DSA, you're not done because that's just the start of the relationship. And there are ongoing obligations after that. So a few things that you want to make sure you have in place. I mentioned that one of the reasons this is a best practice is so that you know where your information is. So you're going to want to make sure that you have some type of data sharing agreement inventory. This has been challenging sometimes for agencies, especially where DSAs are, or those data sharing terms are incorporated in other contracts where our contract management systems may not have specific flags to identify that something includes a DSA. So or that it includes data sharing, and we've seen agencies have more success sort of building that out into the contracting process, so you can quickly pull all the contracts that have associated data sharing. You want to make sure someone's responsible for that relationship and can follow up and make sure that the terms are being followed. If you have compliance and enforcement standards in there, including things like audits, you want to make sure that you're actually carrying through with your portion of those commitments. And then at the end of the relationship, you want to make sure that there's some sort of process to certify destruction or figure out, what that looks like when the relationship ends, and what happens to the data that the recipient has in their possession. So that's the very quick intro, and I'm going to turn it over to Katie to talk about data breach provisions, which are one specific area of DSAs.
Thanks, Matt. So, yes, when you are entering into your contracts, especially around data sharing, you don't really want to think about what could happen when something goes wrong, but it is always going to be better to have some of these terms, or at least think about how you will address some of these terms in case data is breached. So if we look at the list of things that we might want to think about, that includes a general notification requirement, meaning getting notice that there's a potential incident or a breach. What information needs to be provided if that happens? How will you address the mitigation, or how will the vendor or contractor mitigate the damage occurring from the breach? Who and how will you notify individuals? Thinking about the costs that may be incurred as a result of the breach, and that it will survive beyond the end of the contract date, if just in case data is held on to if the certification of destruction doesn't occur as anticipated. So let's look into some of these considerations. So when you are looking at your terms, depending on the type of contract and how sensitive and how prescriptive you are around the data elements, you may want to talk about what the incident response requirements will be necessary if the information is compromised. And so that should include, at a minimum, the requirement of when to notify the data has been either potentially compromised or breached, the timing for getting notice out, the costs, and then the roles and responsibilities of you as the data owner and the vendor as the data recipient. So typically what I see negotiated around these types of clauses is the timing. Sometimes they use language like you'll be notified promptly or immediately, and those may be more squishy terms. So I would recommend a more fixed timeline around 24, 48, or up to 72 hours of discovery so that you can have very early notice that there's a potential incident so that the two parties can start working the incident as soon as possible. And that doesn't necessarily mean that you've made a determination that any information has been breached, but it's just that there's a potential that information may have been compromised. Another thing to think about, and this is also sometimes covered in a cyber liability insurance clause, is who will cover the expenses in case there is a breach. So oftentimes you'll have forensics that need to occur, and you may end up needing to bring in a third party vendor to help with those forensics. And so there's costs incurred there. If it is determined that there is a breach, then sometimes you need to stand up a call center depending on the number of people who may have had their data breached. I would say for larger incidents, which are usually defined as 500 or more, you're definitely going to want to have some sort of a call center or at least stand up a phone number for receiving questions and those types of things. Whether or not you want to provide credit monitoring is another expense and consideration, depending on the type of data that may have been exposed. And then not always is this addressed, but something to consider is if the data is regulated by a potential federal regulator, like healthcare data under HIPAA, which is enforced by the Office for Civil Rights, or IRS 1075 data. Some types of data that the state handles are so sensitive that it comes with potential fines, and so you may want to consider that as well. So we often also see these dealt in either the liability caps in the contract, and sometimes you may also have specific caps around data incidents as well. So those are all things to think about. So another piece of this is how involved do you want to be in the notification process? If you are not too concerned about what the notice will look like, then you may not address those terms in the contract. But if you want rights to review the notice that the contractor would be providing, or at least approve or even approve the notice that the contractor is providing, you may want to think about terms that address that. Sometimes I've seen the conversation on whose letterhead makes the most sense, because if it is a contractor that was handling residents' data and the resident really had the relationship with the state agency and not necessarily the contractor, I have seen agencies want the notice to be on their own letterhead because that's who they have the relationship with, or they sometimes want it to be on the vendor's letterhead. So that's something to think about. You also should think about who will do the notification to state and federal regulators if it's that type of data. Any press releases or media notifications, thinking about the timing for that, who will be drafting that and approving that. If you're, especially for executive cabinet agencies or other elected official agencies that have elected officials, whether how you're going to coordinate with them in terms of the notice and timing and talking points around the incident. And then another consideration is whether or not you're going to have law enforcement involvement if there is a potential that there's a crime that's been committed in terms of hacking or accessing or exposing the data. So the other piece to think about specifically on this is information security provisions as well. And so there's lots of great examples of terms that we have available in our guidance, but also things to think about in terms of encryption standards, network security, access controls, how you're going to segregate the data, if you're going to require the data to be segregated, where the data will be stored and accessed from, whether or not employees need to have background checks, and then the ongoing audit rights that you might have in terms of ensuring that the security requirements are being met. So I'm going to pass it back over to Matt to talk about some of those international data sharing considerations.
Yeah, so this is something that is coming up more and more frequently. And I'm going to talk about sort of two different angles of this. And the basic situation is we all operate almost exclusively in Washington State, but data moves around the world, and the people, the third parties that we are interacting with, don't always operate exclusively within Washington State. And so when you zoom out and look at sort of the global context around data protections, that can complicate how we enter data sharing agreements with folks. So the first way that this impacts us is through the concept of offshoring, which is the basic question of should Washington state data be allowed to leave the United States? Um, so when we're thinking about this, we want to make sure that we're thinking about a couple of ways this can happen. This is similar to like that data processing question I talked about at the beginning about this being pretty broad. So the first way that we often think of first is the data hosted outside the US? So is it like actually in a data center somewhere that is not within the US? But the other thing that happens is even if the data is stored here, is it being accessed or used somewhere else around the world? And so we want to make sure we're considering both of those questions, and the way we handle this question may be different depending on which scenario we're talking about. So the frequent question we get here is there a Washington state prohibition against sending data outside of the US? And the answer is there is not a generally applicable policy. So there are a few specific laws that may be more restrictive if you have particular types of information. And so this tends to be things where there's federal regulations. And the examples we call out here is financial information regulated by IRS 1075 or criminal justice information services information. Those are both regulated by the federal government and do have prohibitions. Another more recent development is around what's called like bulk offshoring. So this is an executive order at the federal level that imposed restrictions and prohibitions on sharing American personal data with countries of concern. So those specific countries are China, Russia, Iran, North Korea, Cuba, Venezuela. So probably not countries that we are doing a lot of business with, but it's helpful to know that that is out there. And this started as an executive order, and it has now been finalized in a rule that is administered by the U.S. Department of Justice. And then the other kind of relevant policy here is closer to home, and those Washington state policies that we do have an international travel technology policy. So this isn't specifically around sending data outside the US, but rather what if we have state employees that want to be doing work internationally, and there's a specific approval process for that to happen. So if you're thinking about whether information should be allowed to go outside the US, the two main categories of concern are there adequate legal protections once it leaves the US? Different areas have different laws. We're not going to be as familiar with them. And do we have assurances that that information is going to be protected once it has left our borders? And then the second related question is, even if there are legal protections, do we have the ability to do anything about it if they're violated? It is much harder to enforce contracts if it happens outside of our jurisdiction. So there's that sort of practical question of even if it's on paper protected, can we actually protect it? So for those reasons, what we typically recommend and what we see most agencies wanting to push towards is starting at least with the presumption that data is not going to be allowed outside of the US. So starting with that prohibition, but then developing a process to consider exceptions on a case by case basis in light of the total risk of the relationship. And having that kind of process really helps to establish some documentation around the decisions being made, and hopefully also establish some consistency over time by virtue of having those decisions documented. So when you're thinking about those specific exceptions, some of the things to think about are, is it storage outside the U.S. or is it just access? One of the reasons why we frequently see this coming up is a lot of larger multinational companies use what's called a follow the sun support model, where to enable them to support you 24 hours a day, they have staff located around the world. So in those situations, they're often only accessing, not storing the information. You want to consider the type of relationship you have with the recipient. So again, is it a vendor working on your behalf to provide you a service, or is it just somebody who wants your data for example, a research project? You want to think about what the specific information is and how sensitive and critical it is to your business functions. Again, the reason for the exception, is it just to provide support for you? You want to look at kind of their general commitment to protecting the information. Do they have a training and governance process that applies to whoever is working outside the United States? You want to look at the specific countries. Like, as I mentioned, there are some in particular that you want to make sure you're not sharing with. And then you want to look at the scope of storage or access. So is it a lot of data? Is it little data? Is it accessed by a lot of people or just a few key people? Is it time bound? So those are all important considerations to take into account, and then again, to document that decision, whatever it may be. The other way that we see uh, the sort of international stage impacting how we enter data sharing agreements is what I'm calling the patchwork problem here, which is not that long ago. It was kind of the Wild West around what kinds of legal protections applied to data. And we've seen a really quick proliferation of different data protection laws, both in the United States and around the world. So here in Washington, we do not have a comprehensive privacy law, but we do have about 22, 23, depending on how you count them, states in the US that now have specific legal requirements for handling personal information. And then when you look out across the globe, again, you see most of the world now has legal frameworks for protecting personal information, and the United States is really the outlier in not having those laws in place. So that really impacts the way that the people that we are sharing data with handle privacy and handle data protection. So because of all that new patchwork of laws that are in place, both domestically and internationally, companies now have really complex privacy compliance programs in place. And those complex compliance programs may differ from company to company. Some may try to tailor what they do depending on where they're operating. Others try to establish like a minimum baseline everywhere they operate. And then the really big impact is that whatever that compliance approach is, it is often memorialized in their own standard terms. So this is often found in what's called a data processing addendum, or DPA. So the impact on us of this is not that long ago. In most relationships, you could start with sort of like what our data sharing template may be and what sort of our North Star may be for data sharing terms. But in the world we're operating in today, most companies especially operate not just in Washington, and they have their own agreement that they've carefully crafted with attorneys, and they're going to want to start with that and maybe more hesitant to negotiate with us about what those data sharing terms are. So In many ways, that's a good thing. Like these companies now have taken on these commitments, they've enacted these compliance programs, they've put things in place to protect information. But it can be complicated. We want to make sure that those terms that are in those agreements are going to meet our policy requirements. We want to have an understanding of what that compliance approach is. Again, do they just say this is how we're going to protect all information, or do they have caveats of like we will apply on a jurisdiction by jurisdiction basis to the extent that the legal requirements apply, which can be more challenging for us. What do they commit to in writing? Is it sort of basic legalese, like minimum standard in the contract, but that in practice they say they do more than that? And then we also want to think about whether they're including requirements that are actually incompatible with our requirements as public agencies. So the most obvious example of that last one, where something may be incompatible, is that a lot of these laws that are now in place across the country and across the world have what's either called a right to be forgotten or a right to deletion, where you can basically have your personal information erased. So a lot of these DPAs are going to have language in there about this right to be forgotten, which is not something that applies to us as public agencies for lots of reasons. You can think about what it would be like if people could ask for their criminal justice information or traffic infractions or mental health records to be deleted. So that's not something that's going to apply to us, and we want to make sure that our contractors aren't agreeing to do something that would violate our rules. And then the other really big thing here is we want to make sure that whatever those commitments are that are in their DPAs actually apply to the information that they're receiving from us. Again, like if you have a contract that says we will comply with the requirements of California's privacy laws, that's great. It means that they're enacting privacy protections, but that means that those requirements don't actually apply to the information that they collect on our behalf because we're not subject to those laws. So what we want to do when we see this come up is make sure that we're trying to add amending language that says that whatever those protections are that they've enacted to protect people in other jurisdictions, that they're going to do the same thing to protect our information. One other thing that's not on here when we're reviewing these DPAs to pay attention to is all those laws apply to personal information, which makes sense. We're here. This is a privacy webinar, but that's not the only kind of confidential information that we share as public agencies, right? So you want to also consider, is it security infrastructure information or confidential wildlife information or something else that needs separate protections that's not covered by the DPA? We're going to take a hard pivot here to the next topic, which is artificial intelligence and how this is impacting our data sharing arrangements. So just at a very high level, right, when we're talking about AI, we're talking about machine learning and similar technologies that enable computer systems to perform tasks otherwise normally associated with human intelligence. So we think most frequently recently around generative AI, which includes things like content generation, but it also includes AI in general also includes things like computer vision and natural language processing. AI is relevant to this topic, the data sharing, because it relies on tons and tons of data. So it requires large amounts of data to train these models in the first place, and then also requires high quality data for the systems to perform as intended. So all that data sharing can mean that we're either creating entirely new data risks or just exacerbating existing data risks. And when we think about how to handle artificial intelligence in our data sharing relationships, again, going back to that like threshold question of identifying when you need a DSA. Similarly, here we need to identify, is a recipient using AI? So there are a few ways that this can come up. One is intentional AI, which is the term we use when like we're procuring a solution because of that AI functionality. Incidental AI is when we have a relationship that's not really related to AI at all, but the third party starts using AI or incorporating AI into processes that didn't used to have it. And then we also have third party AI, which is where we have a recipient that isn't really part of our government, isn't really our contractor at all, but is using AI in a way that impacts us. So, easy example of this would be like if somebody had called into this webinar and started using an AI note taker, right? We didn't invite that. We're not doing that recording, but that's a way some third party's AI could impact us. So ideally, we want to know when that's happening, right? So we do have some a model term here around notifying agencies when a data recipient is using artificial intelligence. And this is language that comes from a DES contract that was part of Executive Order 2401 on artificial intelligence. It's available on the WATEC website, and we have the link in the slide deck. But so this is one of the terms that is covered there, and it also includes these other topics of things to consider implementing as model terms in your data sharing arrangements that involve artificial intelligence. Um, at a more practical level, like some of the key things we want to think about when we're thinking about AI use by data recipients, one of the top of mind things is how are they using the data in their AI model? So can they commingle it with other data? Can they use it to train or improve their model? And the answer to that or we may or may not want that to happen, right? Like with things like large language models, we often probably do not want anybody to use our data to train their model. But if we have things like safety measures around like wildfire detection, maybe we do want them to use our data because it's not particularly sensitive and it can help improve outcomes for everybody. So that really is a case by case determination. We want to think about how much transparency we have around system performance and what's happening in the system, how explainable it is. We certainly want to think about how information is logged and accessible, including what are we putting into the systems and what is the system putting out, what did it do on the back end and what did it access. And then also more of an emerging topic I have here as scope of access and permissions, but really as we see more and more of a move towards agents and eventually agentic AI, where the AI is not only giving an output, but is actually automating some workflow or taking some action, that we want to make sure we have a good understanding of what level of access and permissions does the AI have on the back end. In our recently enacted AI policy, which is Data 04, we do have a couple of requirements around data sharing agreements. The first one on the left here is just a call out that you need a written data sharing agreement when sharing category 3 or 4 data. So again, this is really just like a cross-reference to the data sharing policy we already talked about. That applies equally when you're talking about an AI tool. And the other piece is that if you do not have a data sharing agreement in place, then that means you cannot implement or you cannot put confidential information into those tools. So this is basically to address the situation, for example, of somebody putting confidential information into a public version of a large language model like ChatGPT, just as an example. So this is establishing that that would not be appropriate. The other data sharing agreement piece that we have in that policy is specifically around high risk systems. So high risk generative AI system was defined in that executive order I mentioned, which is a system that has a high risk to natural person's health, safety, or fundamental rights. We do have some guidance around how to make that determination. That again, we'll have this information in the slide deck, but it's basically a determination of what is the potential magnitude of an impact and how likely is that impact to occur. When we're making that determination, we want to think about at least these categories, which is sort of the operating context, how was the information intended to be used, what are the data characteristics, so how is it high quality, is it sensitive information, and then we also want to think about the system characteristics and safeguards and how it has been designed to prevent bad outcomes. So if you go through that process and you do make a determination that a system is high risk, then there are additional contract requirements that apply. So this originally came from that executive order, which is that if you have a vendor providing a high risk generative AI system, then they need to certify that they have a program in place that's consistent with the NIST, the National Institute of Standards and Technologies, artificial intelligence risk management framework. So it's important to call out here, there is not like a third party certification that somebody complies with NIST guidelines. This is more that the vendor in their contract has certified that they have a program consistent with that. So it's like an attestation than an independently issued certification. And that requirement we also carried over into that enterprise AI policy, which pretty much just mirrors what the executive order language was. So that wraps up the AI topic, and I'm going to pass it back to Katie to talk about third-party data requests.
Matt. And just a note on the NIST certification or attestation requirements, just know that, the point of that is to really get to a responsible AI governance program for our vendors that are performing high risk work for the state. So just wanted to emphasize that. And so the way and shape and form that those terms look is not I guess, determined, but it is important that if you are entering into a contract around high risk AI use, that you're ensuring or having the vendor assure that they are following a responsible AI governance program that follows something consistent, which is what the words are in the executive order with the NIST AI risk management framework. So just wanted to emphasize that as well. So thank you so much, Matt, for all of that great content. And we're going to talk about, well, what happens when a third party asks for our data. So there's a couple different ways that we see third party data requests occurring. And a particular area of concern and interest for the state right now are the potential for subpoenas or criminal investigations or some third party investigation where um, a third party is going to our contractors to ask for the state's data. So that's kind of the situation that I'm going to talk about in a minute. We also have other processes around research where we may have third party requesting data. And then there's other legal processes like we think about with the Public Records Act. So we're going to jump into the subpoena issue first. So for the considerations, we're really talking about sometimes agencies receive notice that a subpoena has been sent to one of our contractor that holds state data, and it may require that contractor to produce our data to a third party, and that can be law enforcement, it can be a regulator, and sometimes we don't get notice as well, and I'm going to talk about that instance. We are asking our contractors now with some sample language to do some due diligence in terms of the contractor's responsibility for what is the good faith of the request for this data from the contractor. If it seems like it's an unusual request and not in the course of regular business in terms of some more run-of-the-mill law enforcement requests for information. And then also, we want to propose language that requires that a contractor to document when they receive a request, and that request specifically prohibits the contractor from notifying the state agency. And so we want to know as soon as possible, as soon as they're able to let us know about that. So if we look at some of the sample language that we are proposing, or things for you to think about and maybe discuss with your AAGs, we really want to be reinforcing with our contractors that they will not be accessing or using state data beyond what is necessary, and especially if they're complying with a law enforcement request, subpoena, or court order. And for those types of things, we would like to get notice in advance before the contractor discloses any information, because we want to be able to involve our attorneys to potentially go to court and quash a subpoena, or maybe get additional protection order around the information, or those types of things in case it's being turned over. And so there are some cases where you'll see in the contracts where the contractors will say, yes, of course, we'll give you notice unless we're prohibited by law. And so that is the area right now where we're trying, for the third bullet on the second column here, where we're trying to really ask our contractors to evaluate those very carefully, those requests, and acting in good faith and conducting due diligence to determine whether or not they cannot notify us in terms of the information that's being requested to be turned over. And this is especially important when it comes to sensitive information that the state of Washington has particular concerns around. And that would include things like immigration data. It will include things like reproductive health data or gender affirming care data. So those are the types of things that we want to be especially helping our contractors recognize if they have that data for any reason, that we really do want to be notified if a third party is requesting those. And then if the contractor is certain that they cannot notify us, and because it would be against the law for them to do that, we want them to at least document that and then notify us as soon as they are able to, that the data was requested and released. So that is, I think, probably an area that is newer, that we haven't had to think about as much in the state in terms of how our data is being shared, especially with other federal government partners or other law enforcement agencies. But those are things that I want agencies to be specifically aware of. Another area that we see third-party requests is in research, and this is also very standard. We have there is a specific area called human subject research that is actually under an area of law called the Common Rule. And that type of information sharing does come with a lot of other requirements. And so we're not going to do a deep dive into the human subject research RCWs today, but I want everybody to be aware that this is another area where we see especially sensitive or personal information being shared. And a lot of that work has to be reviewed by what is known as an IRB, or an institutional review board, and they have oversight over the agreements that are required to perform that research. And those things include non-disclosure agreements and confidentiality agreements. And I have listed here a couple of the applicable RCWs, and it lists specific state agencies that are subject to the Washington State IRB. In addition, I did want to highlight that there are actual potential for penalties under that law for release of research records. If there's unauthorized disclosure, it can be a gross misdemeanor with potentially steep financial penalties. And then just to highlight for everybody's awareness, this is more about public records, the other type of area where we may see third-party requests. So this is not necessarily going to be for Category 3, Category 4 confidential information, but I do want to raise awareness that this is part of the proposed model rules that to help address some of the concerns or feedback that I believe the Attorney General's office received around the perception that there had been an overuse of the third party notice. I think provisions in RCW when information is requested under the Public Records Act. And so I just wanted to highlight that this is right now a proposed rule with some edits, and it just went through, I think, a public hearing last month and will be finalized soon. But this is some of the considerations or changes that are being considered in terms of information, the types, I guess the type of considerations that agency may have in providing third party notice. So wanted to make everybody aware of this potential change. So I think we're just about at the end. And so we will go ahead and pause here for questions. Thank you, everybody, for joining us today for this webinar. As Rhonda mentioned at the beginning,